before I get locked up by this low life, and you know he gonna see all this shit and try to lock me up anyway. You can't do the right thing in juvenile court because they don't care what you do. I did the correct research and I found the error of his ways. Basically, when you order somebody to get a psychological evaluation, there are certain things that you have to do also if you're going to be doing it the correct way. He said right here, Father has filed a document that the clerks has entered as a motion. It is not a motion, it's a document filed by Father. Didn't even look at it. He said Father has filed another document today. It is titled as a motion for declaratory relief. A review of the motion shows that it basically, he spelled that wrong, contains a written defense to the contempt matter and asks for declaratory relief from maternal grandmother being appointed guardian. He's lying through his teeth. Let me go get my motion. This is the motion I gave this little weak ass motherfucker. This is why he gonna lock me up. I corrected his ass because the reason he don't want me around my child is because supposedly I'm a danger to him, so I need a psychological report. According to Civil Rule 35 that I'm about to read, when you do a psychological report, when you order somebody to do a psychological report, this is what it says according to the law. This is what he broke. And like I said, I'm gonna show you how he lied about this motion right here. It say right here, order of examination. When mental or physical condition of a party or a person in custody or under legal control of a party is in controversy, the court in which the action is pending may order the party to submit himself to a physical or mental examination or to produce such examination the person in the party custody or legal control, right? The order may be made only on a motion for good cause shown and upon notice to the person to be examined and to all parties, and shall specify the time, place, manner, condition, and scope of the examination and the persons or person to whom it be made. Right here, he didn't do this at all. This is the Civil Rule 35. If you're going to order me to get examination or lock me up, then you're supposed to go by the rules of civil procedure, man. You're supposed to tell me the time, the place, the manner, the condition. This is the Ohio rules that he lied about. Let me go back to his lie. This is my motion for declaratory relief. He gonna say the motion is about, this is lying ass. He gonna say, oh, the review of the motion showed that it basically contains a written defense to the contempt matter and asks for declaratory relief from grandmother. No, it don't. It's talking about declaratory relief from your ass because you supposed to be telling me the right thing to do. You know what I'm saying? So let's go back. Okay. Right here, this is a motion. This is the motion telling him you're not supposed to just say get a psychological report or I'm gonna lock you up. You're supposed to show me right here, as I said, right here, on top. What does this say? The order may be made only in the motion for good cause shown upon notice of the person. Let me get closer. Upon notice to the person to be examined, and let me open it up a little bit. Okay. Open this thing up. What does it say? The order may be made. This is the last sentence. Only on motion of good cause upon and upon notice to the person to be examined and to all parties, and shall specify the time, place, manner, condition, and scope of the examination and the person. Meaning, according to Ohio Civil Rule 35, if he's going to order me a mental exam and say I'm gonna lock you up since you ain't had your mental exam, you're supposed to be telling me the specific time, place, manner. But let's continue though. The state court judges have an affirmative duty to ensure procedural safeguards sufficient to protect the fundamental interests enumerated in this motion at strict scrutiny. Anything in the constitutional laws of any state to the contrary notwithstanding. What does that say? Because petitioners have state authority to deprive persons of liberty. The Constitution imposed on them the state's in-commitment duty to see that no deprivation occurs without adequate procedural protection. He did not have any procedures. The procedure is just supposed to show me where to go and what to do. He didn't do none of that. He go to executive order that tells you about transparency. By the authority vested in me by the president and by the Constitution, the laws of the United States of America, hereby ordered as follows. Section 1, policy. The rule of law requires transparency. Regulated parties must know in advance the rules by which the federal government will judge their motion to strike with prejudice action. Let's continue though. It says, The Administrative Procedural Act. This was enacted to provide that administrative policies affecting individual rights and obligations be promulgated pursuant to certain stated procedures so as to avoid the inherent arbitrary nature of unpublished ad hoc determinations. This Freedom of Information Act, all types of stuff talking about procedure. So like I just want to point out real quick before I end this right here. As you can see right here, according to Civil Rule of Ohio, what he's supposed to follow. The last sentence in this page, the order may be made only, say right, let me read the whole thing. When a mental or physical condition of a party or a person's in the custody or under the legal control of a party is in controversy, the court in which the action is pending may order the party to submit himself to a physical or mental examination to produce such examination, the person or the party custody or legal control. So I was told to do a mental evaluation, or I can't see my child, or I'm gonna get locked up, right? Let's continue. The order may be made only in a motion for good cause shown and upon notice to the person to be examined and to all parties, and specify the time, place, manner, condition, and scope of the examination. He didn't do none of that. He didn't tell me no time, no place, no manner, or scope of examination of person to person. The state court have an affirmative to ensure procedural safeguards. He's not doing that. He's just saying get examination. If not, if you don't get examination, I'm gonna lock you up. I ain't gonna do what I'm supposed to do. I ain't gonna know the law. I've been a lawyer for this long, but I ain't gonna, because I'm just gonna tell you to do something and go do it. But a lot of people don't know this. And he read this, the law that he's supposed to follow, and then he turn around and lie. Oh, review of the motion shows that it was basically contains a written defense of the contempt matter and asking for declaratory relief from the maternal grandmother being appointed guardian. No, I'm not saying that. It's obviously saying if you're gonna give me a psychological report, do it the right way. So like I said, he gonna lock me up being a lying piece of shit. I know it's it maybe go over people's head, but basically he lies. Every time I put something in the court, it don't matter what you do. It don't matter if you do right by this court. It's about greed. But like I said, all praises, all honor, and all glory goes to the Holy One of Israel, whose name alone is Yahweh.